Hello, everybody. Hello, Sir Philip. Hello, Linda Applegate, sweetie. Oh, hi, Ava. Hello, Ava. How you doing, girl? Who's ready for tonight? Huh? Is Ava ready for tonight? Is Bandit ready? Oh, we're ready for Blue Buffalo treats. That's what we're ready for. Isn't that right? Isn't that right? Yes, yeah, good girl. Oh, Mama dropped the whole bag. Dropped the whole bag. Hold on. I got this. I got this, I swear. I swear. Just a minute. Oh boy. There we go. I done it now. Oh, hello. Oh boy. Hi, Billy. I got Billy, I got Bandit, I got Ava. Just missing Tiny Kitten, Esquire, and Earl. Hello, Nana Laura. Hello, Mortimer Dick, my sweetie. Hello, C-Rex, honey. I hope you're feeling better. I started it earlier. You don't do that. You're not kicking me out of my own stream tonight. She's sure going to try, though. She's going to try. Hello, Chinny. Yep, that's Bandit. And then Billy's in the window right over there. You got one more. Did you forget how to count tonight? Ava, the world needs you. Oh, yeah, I started exporting a lot earlier tonight because I knew that it would take a while. And thankfully, I seemed to have timed it quite well because it just finished. And I don't have to spend a half hour waiting for it. Neither do you. We get to have fun right away. Oh, you quit it over there. All right. Yay. The Sparky S2 drive is prepared to go. There we go. Oh, whoops, which mouse? Not that one, this one. There we go. I'm on it. Yes, if you cannot tell, I did not take Benadryl or my pain meds tonight. So I should be able to stay awake. Oh, last night was so terrible, and I apologize to everybody. I took the stream down. I put it on private. I took it down because, new viewers would not understand. You guys know me well enough. You know that I'm not, that I don't do that in excess. But I was in so much pain last night. It was ridiculous. I look very American. Well, I think that's the best compliment I've gotten tonight. Hello, my sweet K-John Boom. Hello, Rocky Lennon, honey. I'm so good to see you. Hello, Spider-Man, sweetie. That tail is lethal, I swear. It keeps smacking me in the face. What on earth? You quit that. You. Oh, Mortimer Duke, I love you so much. I hope you really do know that. Thank you so much for being so kind to me. Well, I think that's a valid excuse. You get a pass. Auntie M's not here to hand them out, so I guess it's on me to hand them out. So I say you get a pass. Honey, thank you. I love all of you so much. You guys make my day. You make my night. Today was my daughter's 19th birthday. Yes, my baby girl, my sweet, sweet baby girl is 19. Yep, in college, living on her own, well, with friends. She's in a dorm right now, but she's already got, leasing stuff signed for next semester. Rocky Lennon, thank you. Thank you so much. Oh my gosh, you guys are the best. You really, really are. Hello, Crystal Canarium. Welcome. Thank you. Oh gosh, I can't even tell you how proud I am. She's amazing. I could not ask for better. I couldn't. It would be selfish and greedy and ungrateful to ask for better. She's so amazing. Billy, what's up, buddy? I see you lurking. So to you and everyone else lurking, give a great big hello and a love. Oh, happy birthday, Nana Laura's daughter. That's so cool. Yeah. Oh, I have plenty of meows coming from Tiny Kitten because she's in heat again. And Ava. They both are. It's kind of like the theme of the house right now. 13 beautiful months. Wonderful months. Thank you so much for being here with me. You are at every live stream. I swear, I don't think you've missed one. I think since we met, you have been here every night. Right when it starts, I load it and there's Nana Laura. I just cannot tell you how grateful I am for that. For you guys showing up every night and loving me. It means everything. It does. I have the best subscribers in all of the world. And I can say that because y'all are from all over the world. Thank you all. You guys are the greatest. So let's get right into the fun tonight. I agree. Billy has spoken his piece. This is probably the most fun part. I'm trying to find where I put it. And you guys all probably sitting there giggling at me. Yep, that's how it goes.
Ms. Orr is here for a pretrial conference. Is this going to be a plea today, Mr. Greer?
Yes, Your Honor.
Is that correct, Ms. Orr? Yes. Would you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Put your hand now. All right, and Ms. Robinson, is there an offer in this case?
Your Honor, the offer is the defendant enters a plea to counts 2 and 3 to retail fraud second degree and possession of a controlled substance, the analogs, then the people will dismiss count 1, which is a possession of methamphetamine. People preliminarily score those guidelines as 0 to 6 months. And we would offer a sentence within guidelines as they are scored at the time of
I've got
sentencing.
midpoint. Epic midpoint. Oh, shoot, I read that. I'm sorry. What too close to, what are they?
0 to 6.
Okay, that's fair.
All right.
It's gonna be the same, Your Honor. What I did is I looked down, I had 2 close together, and I looked at the second one, which is a midpoint.
All right, so your understanding of the agreement is count 2 and count 3, dismiss count 1, including the advisory guidelines of 0 to 6 months.
Yes,
All right, is that your understanding as well, Ms. Orr?
Yes.
Okay. The charges that you're entering a guilty plea to read as follows: that on or about June 29th, 2024, that you were in the city of Fremont, Nuevo County, state of Michigan, and they committed the crime of retail fraud in the second degree, that you did while Walmart was open to the public, steal property of that store that was offered for sale at a price of $200 or more. But
Your
less than
Honor, if I
$1,000.
interrupt, I think we pled to that in district court. Huh? Yeah, we pled last week in district court, I thought.
Yeah, that was all done.
I'm not sure. I think you might have taken the plea for Judge Stay.
These are on the same information, so I don't know how that.
There'd be no reason, if this allegation is right, for Judge Stay to not be on it, because this was June 29th. He took the bench in April, so there wouldn't be any reason to do it on a conflict basis.
Yeah, I think what's happened before is they'll put it on the same information sheet, and then they'll break it down to district court, circuit court. I might be wrong, but I think she pled to that.
Your Honor, she had a clean sentence on a retail fraud 3rd degree last week. That was a separate case.
That's a separate case?
Yes.
Okay, fine.
Yeah, it's hard when you have so many and you have to keep them all, in order, keep track of them. And even the lawyer can't keep up with her thieving.
We're good then, Judge.
Okay, all right. So this is a misdemeanor, which carries up to 1 year in the county jail and or $2,000 fine plus cost, or 3 times the value of the difference in property stolen, obtained, or attempted to be stolen, whichever is greater. Do you understand count 1, the maximum penalty?
Yes.
Count 2, same date, same location, that you did knowingly or intentionally possess the controlled substance hydrocodone. This is a felony which carries up to 2 years in prison and or $2,000 fine plus cost. Do you understand count 3 in the maximum penalty?
Huh?
It was 2 months.
Okay, you're not charged.
Oh, okay.
This is the meth
Okay.
case.
Yes, Your Honor. I want to plead guilty.
Your Honor,
I misunderstood. I'm sorry.
Just let him, Your Honor, would you repeat that last line? I'm sorry.
You don't need more time to talk. We can.
I don't need more time to talk.
She seems to be talking to you the whole damn time, so.
I don't need-
What's going on?
I spent about 45 minutes on Super Bowl Sunday going over this with her. I don't understand what she doesn't understand. So she knows what the deal is. I don't know what else to say.
So Ms. Orr, if you need more time to talk with Mr. Greer, it's not really. Well, I keep trying to talk and then you start talking to Mr. Greer again. So I'm just letting you finish having your conversation with Mr. Greer before I get my chance.
We're done here.
So, Ms. Orr, as I was indicating, if you need more time to talk with Mr. Greer, I can reschedule this. But if you don't think you need more time, you need to pay attention to what I'm asking you and the information that I'm giving to you. You can't listen to what I'm saying and talk to with Mr. Greer and have him respond to you all at the same time. It doesn't work.
Okay, I'm sorry.
Do I have your attention?
Yes, sir.
Count 3 says that on or about June 29, 2024, that you were in the city of Fremont, Nuevo County, state of Michigan, and that you did knowingly or intentionally possess the controlled substance hydrocodone. This is a felony which carries up to 2 years in prison and or $2,000 fine plus cost. You understand the charge and the maximum penalty.
Yes, Your Honor.
You have a sentencing agreement that you be sentenced consistent with the advisory guidelines. Do you understand that?
Yes, sir.
The prosecutor estimates those guidelines to be 0 to 6 months. Do you understand that?
Yes, sir.
Your actual guidelines could be higher or they could be lower than that. It depends on how I score them at the time of sentencing. Do you understand that?
Yes, sir.
You would also be consenting to a term of probation. Do you understand that?
Yes, Your Honor.
Is that your complete understanding of the plea agreement in this case?
Yes, Your Honor.
Have you had sufficient time to consult with Mr. Greer about your charges and this plea agreement?
Your Honor, I need one moment with her, if I may. Got it.
Understand that you'd be consenting to a term of probation.
Yes, Your Honor.
You had sufficient time to consult with Mr. Greer about your charges on this plea agreement.
Yes, Your Honor.
Subject to the plea agreement, how do you wish to plead?
Guilty.
Understand that if I accept your guilty plea, you're giving up the right to have a trial of any kind.
Yes, Your Honor.
You also understand that you're giving up certain constitutional rights and other rights you would have if you went to a trial.
Yes, Your Honor.
You advise you of those rights in writing, which you signed today. Did you read that document?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
Has anyone threatened you to get you to make this plea?
No, sir.
Has anyone promised you an outcome different than what we place on the record?
No.
Are you entering this plea of your own free choice?
Yes, I am.
Do you understand that if I accept your guilty pleas, you're giving up the right to later claim that this plea was not your choice, or that it was a result of any promises, threats, or inducements which are not disclosed to you today?
Yes.
Do you understand that I'm not bound by this plea agreement? But if I don't go along with it, you can withdraw your plea.
Yes.
Do you now give up the right to have a trial of any kind and all the rights that you would have at that trial? Or do you still want to plead guilty?
Yes.
Is it true then that on or about June 29, 2024, that you were in the city of Fremont, Nuevo County, state of Michigan?
Yes.
Did you go to Walmart?
Yes.
Did you steal something from them?
Yes.
What did you steal?
So a canopy. There was a battery.
So you stole a canopy like an easy up?
Yes, sir.
Okay, anything else?
I think there was a battery on the bottom of the car,
What kind of battery was that?
for a car battery.
How much was the canopy worth?
The sticker on it said 150, and they said it was a different price than that.
How much was the battery?
I think maybe $68. I'm not positive.
So the sticker on the canopy that you stole was 115, but they're claiming that that was too low, that the actual price was higher than that?
It was 150, yeah, and they said it was higher than that.
How dare they charge you retail price for the items you steal?
And that was the price that was on the canopy box itself, yes.
115?
No, 150, sir.
150.
Yes, sir.
So the combination of these two items had a value of greater than $200. Is that
Yes.
correct?
Yes.
Now, how'd you steal this stuff? What'd you do?
Just, we had went out to the back to check out the other stuff. And I was under the understanding at the time that the lady had checked it out. We had to go up front to do our groceries. And I went out front and done the groceries, and they said that the woman never checked it out. So they got us for walking out with it.
Thought that you had actually paid for these items?
Yes, we had two separate things. One was paid for out back, because that's where we were just gonna go out the back, like, because our car was right there. So, and then when we got up front, they said it wasn't on the things, and I paid for all the groceries. But it was just a matter of misunderstanding. I had the money to pay for it. I mean, that's what they thought.
So it doesn't sound like you think you're guilty of this.
Yeah, I guess. I mean, I don't know. I just want to get, I feel like they thought that that's what we were doing. So I'll take the blame for it, you know. I was under the understanding that she had checked it, and they said that she had. So yes, I am guilty of basically walking out of the store.
Your Honor, perhaps we should just adjourn this.
Obviously, I'm just pleading guilty.
No, well, you're pleading
No.
guilty, but you're telling him you're not guilty.
No, there was a misunderstanding. I thought she had, so,
That's not good enough.
all right, well. All right,
We'll try this again on another day. Why don't we come back on June 7th at 2 o'clock?
Is it 2 o'clock, Your Honor?
Yes.
Thank
2
you.
o'clock.
April, Judge?
What's that?
You mean April?
What
not
did I
June?
say?
You said June.
Oh, I'm sorry. I meant April. April. Now, hang on.
April 7th?
Is Mr. Higgins going to take a plea, Mr. Greer?
No, he wants a different lawyer.
Then we can, we'll save a date, different date for him. So, okay, April 7th at 2 o'clock.
Thank you, Your Honor.
Your Honor.
All right, this is the People versus J. Daniel Saylor. It's case number 231331 FH. Mr. Saylor, you filed a motion for reduction in your sentence. You can go ahead and tell me why you think I should grant this.
Since I've been here, I've had a lot to think about. Knowing what I did in the past to get here it wasn't the right choice. Now I can see the better me. You know, I've had a lot of time, like I said, to think about this, and I feel a lot better about myself. I've been working with CMH. I've talked to a lot of mentors in here within the church, and been working on myself, been reading a lot of self-help books. I just feel like I could be a great member of the community again if I had a chance. I've been good to all the staff here. I think they're pretty good staff we got here. Just been doing what I had to do. You know, been here for 9.5 months, and I feel like I'm rehabilitated enough to get out there and start doing my classes and doing my probation and moving forward.
When's your out date?
My out date is February 28th. Been working in the kitchen since September 16th as a cook. Right along with a lot of food.
I'm just looking at my notes here. It looks like at one point you rejected a no prison offer. The offer was withdrawn. Looks like your case was progressing towards trial. And did you end up making a deal shortly before trial?
Yeah, for a year in the county here.
Yeah.
I ended up doing a year. So far, I got 9.5 months.
All right, anything else that you want the court to consider?
That's it. I just, like I said, you know, I feel like I've been rehabilitated. I definitely got to think about the things that I've done wrong and that they were the right thing to do. As I'm working on myself, I feel a lot more confident that I can be a better person out there. You know, I had a lot of anger and hatred in my heart when I came in here.
How'd you get rid of that?
I got rid of it by talking to people, especially Richard and CMH right here. And the church people, and just found love in myself. You know, a lot, like I said, a lot of self-help books about depression and anger. I've read like 5 or 6 of them. Really helped. You know, just letting go. Like the Let Go book. I read that, and that's really helped me. It's about just surrendering yourself and just actually sitting back and looking at the outcome of the things that you did wrong and the outcome of things that you can do better. And I just feel like that's me.
He now lives by the serenity prayer.
Okay, all right. Ms. Robinson, anything that you want the court to consider?
Your Honor, it appears that this case was originally set for jury trial. Looks like selection was to be on April 30th of 2024. The trial to start on May 1st. The court in January issued an order revoking this defendant's bond due to violations of his condition and having contact with the victim. It also appears that that trial was eventually canceled due to the active warrant that the defendant had. I have a notice from the court dated Wednesday, March 20th of 2024, where notice is hereby given that the jury trial set for those previously mentioned dates is canceled due to the defendant's active warrant. There was a pretrial hearing in June. Then there was another one in July, at which time the defendant did enter a plea. Looks like the plea on, or the guidelines on the domestic violence third offense were 10 to 23 months. The guidelines on the carrying a weapon with unlawful intent were 12 to 24 months. The people made a no prison offer. Your Honor sentenced him to 12 months in the county jail. I don't have the normal note in here from my staff, but we are unaware. I am unaware at the time of any incidents that he has had at the jail. However, any reduction would put him below the guidelines on his plea. So that is all the information I think brings you fully up to speed to make your decision. Thank you, Your Honor.
I haven't had any incidents in here whatsoever.
Okay, well, good. All right, well, these are always hard decisions to make. I mean, you only got 18 days left to go. So part of me says, just what's another 18 days? 18 days more going to be, make you any better or worse than before? But the last guy was in front of me, he only had 20 days left to go. So it's like, well, do I grab it, give it to you and not to him? But ultimately, just kind of looking back, I can't say that I was unfair with you. I mean, typically when people violate the bond condition, don't come to court, I would be very hesitant to give them the deal that they had on the table before they did all the other bad stuff. So the fact that I kind of broke from tradition and allowed you to do the no prison plea after all that, says to me that I was being fair with you. At this point, if your guidelines are 12 to 24, I don't see any compelling reason to go below your advisory guidelines. It sounds like you're in a really good mental place right now. And if you keep that up, you're going to do really well when you get out. Sometimes it's easy to keep that positive attitude in the jail because all the pressures of life aren't on you. So when you kind of get out, then it gets a little bit harder. But I do see from the paperwork that you got a job waiting for you, right?
Yeah, hopefully still. I mean, right now, like I said, trying to get out here because, I mentally transform myself into a better person. The 18 days, it would be nice. I could get, hopefully, some things on the ground and not lose a bunch of stuff. I mean, since I've been here, I've lost a lot of things. I've lost family members, dear in my heart. I've lost possessions, property. I mean, my love, everything. So, it is. I'm obviously all really up to you. So,
Yeah. Like I said, there's no reason that I can see to go below the advisory guidelines. So I wish you the best, but I'm going to deny the motion.
Your Honor, I need to correct what I said before.
Okay.
I looked in the wrong spot. I have 3 incident reports from the jail involving Mr. Saylor.
Oh,
One was dated June 4th, one was dated July 18th, and one was dated November 8th. And November 8th, he caused a disturbance in the kitchen, and there was a report made on that. So I do believe he has had 3 incidents that have resulted in reports from COs since his time in the jail.
But he is reformed now. So you can just disregard those.
yeah, still in the kitchen, certifications first.
I can't understand what you're saying.
I said, I'm still in the kitchen, certified cook. But I don't see what the incidents were. I had a brother that was in here too as well.
I
Say
believe,
what the incidents were.
yes, Your Honor, in June 4th, it appears that he was fighting with another inmate.
Never fought.
I gave you a chance, eh?
And an inmate Hines, it appears that he was involved. It says inmate, this had to do with inmate Hines and Sailor were involved in a physical altercation in which OC spray was used to stop the fight. And it goes on, there was another fight at the same time. It looks like that was involved in trying to start a riot. That was not him, but it was at a similar time. It's in the same report. So apparently he was involved in a fight that resulted in OC spray being used to break that up. In July 18th, one of the there was a CO that had smelled the odor of hooch coming from a cell, at which point Mr. Sailor, while they were dealing with other inmates, was referring to the officers as dickheads. They told him that was being insubordinate, and he then rang into the Delta controls asking for an officer to speak with him. When they opened the door, he said he wanted to speak with the sergeant, so they closed the door. Then he put his face in the D1 hatch and stated that my wife fucks me in the ass. At that time, more deputies arrived and removed him from where he was and escorted him to T6 without incident. Then it said detainee Sailor will be relocated for 30 days and a 15-day review per the sergeant, and he will be placed on a 15-day e-cig restriction. They also confiscated an e-cig at that time, and they were going to dispose of it. I don't know if that was from him, that it was
Is it the right
removed.
Sailor?
Yes.
It's not the right sailor.
Stop, one at a time, stop. I'm asking her.
When we asked for his reports, this is what we got. They indicated that this was him, J. Daniel Sailor Jr.
The woman I never got locked in D1, ever. I've always, I had 3 cells since I've been here.
And then on November 8th of 2024, inmate J. Daniel Sailor Jr. caused a disturbance in the kitchen after being caught sending messages to his brother. And then apparently he was placing a note in the tray for his brother, Michael Sailor. Kitchen staff told him that he could be removed from kitchen work. And then Sergeant Britton and another CO went to investigate. They were given the note and talked about how Jay was a cook and he saw their mother. He asked for Tim's contact number and how Crystal left him. So he was looking for another girlfriend, if Michael was aware of anybody who was available. Then another inmate asked why he was being moved from the kitchen.
Oh, yeah. Yeah. Don't let his wife hear you reading that.
And yeah, so it looks like that one, he was sending notes he was caught sending a note to his brother through the trays in the kitchen.
The note to my brother, I asked, I wrote, he had bought a pizza tray. And I said, hey man, keep your head up. I love you. That's all that said. I've never been locked in D1, ever. I never sat there and got out of line with the seals, and definitely wouldn't say no one was fucking me in my ass.
I believe
I
it
think that's
was.
what they're alleging, you were saying that to one of the
Yeah, no, but I mean,
Yeah, correction.
this is unfair to me at this point. Because I would never say anything like that.
Sir, I denied the motion before I had any of that information, so
I know,
I'm not
you
even,
gotta get the paperwork right.
I'm not even considering that information. I'm going on just the fact that your guidelines were 12 to 24, and there's no reason to go below those advisory guidelines. I'm
All
not
right,
considering that, so it's true.
Can I ask another question? Did the charges on my thing get dropped from knowingly assaulting a pregnant woman? Because that's not right either. There's someone in this courtroom right now that can tell you that.
It's all under the same statute. People that get confused a lot like that, because it's knowing assaulting a pregnant woman or domestic violence. It's all under the, stop, you asked me a question. It's all under the same statute code. It comes up quite a bit. That's just the way it's printed out. But there's, you're not the first person to raise that. I wish it was different. It's the way the system kicks out the information.
But it's a guy. So how is it domestic when it's a guy? It's a
Sir,
guy that lives on.
Denied your motion. I've heard what you have to say. It's all continued. Page People versus John Jeffrey Stewart. Mr. Stewart is here for a motion for reduction in sentence. You can go ahead, sir.
Correct.
Is there anything that you want to tell me?
Oh, yes, yeah. Well, since I've been here, I've been floor trustee over the jail. During that time, we painted the interior hallways. I've never had any issues with any of this, COs, gotten in any kind of trouble. As far as getting out, I've been in regular contact with my people from AA and my church. My pastor's even come to visit me a few times here at the jail. I've got my community service. I've got that lined up for when I get out. I've got everything in place for my support system for when I get out. Successful. I've had a whole lot of time reflecting here. And instead of dwelling on the negative, I've tried to use it as time to better myself. I've done a lot of reading. You can ask anybody in there. I've probably read over 100 books at least.
Wow. Over 100. He should talk to that dude that read 6.
Not to mention Bible AA book. I've been trying to apply the AA principles that I know to the best of my ability while I'm in here. Drinking is obviously not an issue with me, but I've got great support for when I get out. It's I've got a lot of people behind me in this, including myself. This is no place for me. Too old for this crap. I've got a good life outside of here, and I intend to live it to the fullest. Not be jeopardy to society by drinking. Like I said before, the best amends I can make to anybody is to stay sober. That's what I want for myself.
All right, thank you. Ms. Robinson, anything that you want the court to consider?
We've reached out to the jail. It's the information that people have that this defendant has had no incidents that he's caused any problems since he has been lodged at the jail. And there's nothing further that I don't think the court is already aware of. So that's all we would like to offer before the court makes its decision.
All right, the court is going to deny the motion for a reduction in sentence. Mr. Stewart, you were the benefit of a Cobb's agreement at the time of the plea, which called for 7 months. You had 3 prior drinking and driving convictions. You had recently gone through sobriety court, went back to drinking. Your bodily alcohol content was 0.316. I appreciate that you're doing well in the jail, but just philosophically, I don't agree with these motions. I think people get a fair shake when they see them the first time. I mean, we have a lot of access to a lot of information. We generally follow the philosophy of, if I'm going to err in a sentence, I'm going to err on the low side of things. So I just think it's silly that people could come back and ask for reduction in the jail time. The people, I think, should be able to come back and go, you know what? I think they ought to get more jail time. I had more time to think about it, and I think they should go to jail for longer. But that's not the way it works. It's just kind of one way street. For those reasons, the court's going to deny your motion.
Okay.
Two 5-1-3-5-4-3 FH set for the pretrial conference today. And Ms. Robinson, is there an offer that you're making in this case?
Your Honor, there had been an offer in this case. The people are not changing that offer from the plead to count one, dismiss the habitual notice. The people score the guidelines at 10 to 23 and would cap at the midpoint of the final guidelines. But it's my understanding from speaking with Mr. Greer that he was intending to address the court today regarding whether or not there should be a different attorney on this case.
Okay, well, go ahead, Mr. Greer.
Thank you, Your Honor. I went to the jail yesterday, and when Jason came into the room, I could tell he was not in a very good mood. And so I said, okay, here's what we're going to have a pretrial tomorrow. And he just said, you're violating my due process. He kept bringing up due process and that they didn't search the right thing. And all I was trying to find out was about the search. I kept saying, now tell me about the search. He goes, I don't want to talk about that. That's violation. And he started yelling. Then he got up and he said, I'm done with you. And he walked over and hit the button. And the guard could tell he was kind of in a mood. She didn't go anywhere. I mean, she was right by the door. And so she instantly opened the door. And then he walks back like he wants to talk. I said, just get him out of here. Get him out of here. I don't want to talk to him. I don't need to be sitting here on a Sunday getting insulted by him. I said, just go. So get him out. He filed a motion for a reduction of bonds so we could go out and hire a lawyer. And I thought, he doesn't want me anyway. And so, but I could get nothing accomplished yesterday. All I wanted to do was ask him questions about the search. I think it's iffy. But I didn't, and they didn't have right. They searched once, it blah, blah, blah. Just went on and on and on, not answering my questions. And, I've represented Jason a lot, and he's always threatening to get a different lawyer and never does. And we end up with a pretty good deal. But, I wasn't even thinking a deal. I wanted to get the information on the search, which I think is questionable. Here we are.
Can I talk?
Yes, sir, go ahead.
Okay, I filed this probably almost a month ago.
No, you sent it to me, and I told you I wouldn't file.
No,
I don't know what this is.
It's a reduction of bond.
yeah, but it was 2 or 3 weeks ago.
You guys can settle your differences later. So
I
I
don't,
want to file a motion for reduction of bond. Mr. Greer said he wasn't going to file. Okay.
It was
fine.
January 13th, I'm sorry.
my thing is I'd like to move for a dismissal because of illegal search and seizure, because they didn't do their due process. Because any other time I came with a domestic dispute or something, they always left my pot alone, even when it was illegal and stuff. And my truck was on private property and I wasn't even driving it. So, and when the officer said he wanted to search my truck, he said weapons, not illegal substances or anything of that sort. So I feel
Mr. Higgins, where did you get your law degree from?
nowhere. I'm just talking out my hiney, really. But
So why don't you let Mr. Greer look at the issues for you?
I was trying, but you wouldn't.
No, you weren't trying, Jason, come on.
I
You wanted to know, you were mixing up the two searches. Apparently there was a search a couple months earlier where he had a bunch of stuff and they didn't arrest him. I don't care, it didn't matter to me. I'm talking about this search for a bond violation, because he wasn't on probation or anything. So it was a bond violation. They were just investigating it.
This attorney is just something else. I don't know what yet, but he's something else.
He let him search for weapons, but
So
I don't know, it wasn't clear. I couldn't see if he gave him permission, but he wouldn't answer my questions.
I gave him permission to search for weapons, not.
hang on, so you've entered a not guilty plea. I don't want you making statements about your case.
Well, you've gotten further with him than I did.
So, Mr. Higgins, the The search and seizure issues are very fact driven. Okay, and Mr. Greer was probably trying to get to some certain point or certain fact. And he can't challenge the search. He says he wants to. He can't challenge the search. He needed some information from him. And for some reason, you wouldn't give it to him.
Well,
So do you want to hire a different lawyer?
if we could, I'll talk to him for a second and we'll see what we can come up with real quick. I don't know if he wants to.
Well, I like Jason. He just gets in moods, and so do I. And by the time he left the cell, we were both standing.
I mean, if he wants to try to help me with
I absolutely will.
illegal search and seizure, I'll listen to what he has to say.
See, Your Honor.
I almost feel like I need to ask you guys to hug it out.
Yeah. The problem is it was a bond violation or bond restriction. And so the police report is 2 pages. It doesn't give me any information. And that's what I was trying to glean yesterday.
Well, why don't we give it another try?
Thank you.
Why don't we come back on March 17th at 2:50,
That's fine.
and then hopefully you guys can have a meeting in the mines and figure out if there's grounds to challenge the search.
Your Honor, he's asking about a bond restriction or a reduction.
Okay,
I
I don't know anything about it. Ms. Robinson, do you know anything about this? Why you might want to bond
please be
reduction?
quiet.
I know that, at least at the time of the PCC on December 27th, he was set for a district court jury trial on January 3rd, as well as a bond violation hearing on January 2nd. And that according to the report, this original charge stemmed from threats he was making against his parents, threatening to kill them with a baseball bat. That was while he was out on bond in district court. So based on that, and then the fact that methamphetamine was found in his possession, we believe that the bond, which is set at $10,000 cash or surety, is appropriate.
Okay. Mr. Greer, what do you know about all that?
Well, now that Ms. Robinson has brought it up, I didn't represent him on that, but I remember her new assistant was trying to figure out whether or not this trial was going to go. And then apparently this stepped in the way, and so they set that one on the back burner, I guess. And so, but you know, Jason has had similar problems with his parents and has made similar threats. And so it's something when I think it was Grant, I think, that came out there, maybe the sheriff's department later, but they're very well aware of the situation. And so
Who hasn't threatened to kill their parents with hammers or machetes or axes? I mean, come on. It's just a little threat, Your Honor.
I'm sure they didn't waste too much time to verify it. They wanted to get out there and make sure that everybody was okay. So.
All right, so he was out on bond
Yes,
in the district court, some sort of assault type thing.
yes,
He's alleged to have violated his bond.
yes,
He had a jury trial set, but then they charged him with this possession of methamphetamine.
yeah,
And that
yes.
And that was found some methamphetamine as they were investigating this alleged bond violation.
Right, yes, exactly. They went out and from what the police report indicates is that they searched the truck. It doesn't give me a lot of information as to how. I didn't know whether they were going to impound the truck because, you know, he had this bond violation or what. I had no idea, but they did search the truck and so for weapons, he says, and the police report alludes to that. And then they went back again and found some black case that was in the car that obviously couldn't have held weapons, maybe I guess a small gun or something, but they looked at that and they opened it up and there was a couple bags of meth, right?
Supposedly.
All right, well, with a $10,000 cash or surety bond, I cannot find that the magistrate abused their discretion. I can't see any reason why to go any lower than $10,000 cash or surety bond. Given that he's got 2 prior felony convictions within the last 2 years, and he was on a bond. So that's an extremely low bond in this situation. So request for reduction of bond is denied. We'll have you come back from the pretrial conference on March 17th at 2 p.m.
Thank you, Your Honor.
Oh my gosh. The whole premise of his argument was that the search didn't count because they found the meth when they were actually looking for guns, and they had the right to look for guns, but not the meth. But then he says, well, they found this black box that couldn't have held a weapon. Well, maybe a small gun. Okay, then they had a right to go in it by even your own stupid logic. Oh my God, I just can't with this guy. Oh man. Yes. Oh. Tradesies, Your Honor. Yeah. Oh my God. Oh. Yeah, I just can't with this guy. I just all day was screaming at my screen, and I'm still doing it.
All right, so this is People versus William Michael Stowell. It's case number 2413456 FH. Mr. Stowell, you filed a motion for rejection of jail sentence. You can go ahead.
Yes, sir.
Go ahead and make your argument.
That's it.
Go ahead and make your argument. Tell me why I should grant this.
Your Honor, I've, since I've become incarcerated, I realized that the things I've done was, or the things I did was not good. I missed out on opportunities on watching my daughter grow a little bit and learning some things that, some first time things that kind of hit me hard. Since incarcerated, I've been incarcerated since October 8th. I became trustee on the 24th. I was in the kitchen cooking all the food for the jail. I stopped doing that January 20th to become third shift night trustee, which I had free roam of the jail. Since then, that's what I've been. I'm just asking for a reduction, sir. I'm ready to go home. Ready to spend time with my family. I learned from my mistakes. I'm not hoping not to do these things again. I just want to get out and be with my daughter.
How much time do you have left to serve?
I have 20 days. I get out on the 3rd. That's with a good time.
You got a 6-month sentence.
Yes, sir.
You remember what your advisory guidelines suggested at the time?
I had 2 different guidelines. I was sentenced to 24 months probation and then 6 months jail time.
Remember what his guidelines were?
0 to 17, according to the PSI, Your Honor.
Okay.
The offer was a cap at midpoint of those guidelines.
Is this your first methamphetamine conviction?
For in this state, yes, sir.
But other states you had convictions as well?
Missouri, I got out of prison in 2017, got off parole in 2019.
That was for a meth charge there?
Yes, sir.
Do you have other controlled substance charges or convictions?
Not that I know of. Not in this state, not meth. I think I have a charge from 2012 for cocaine. But they ran that with my charges concurrent with what I was doing with down in Missouri. When I came back up on parole, I was arrested and they just took my license for a year.
So what's your plans when you get out?
Take care of my family and continue working.
Where you work? Where are you gonna work?
I run a roofing crew
For who?
for a friend of mine named William Hoxie, Residential Renovations.
He's gonna take you back?
Yes, sir.
Have you done any work on the substance abuse issues in the jail?
In jail,
Yeah.
I didn't think they offered it here. Because I haven't heard anything of them offering any kind of substance abuse in this jail, sir.
So is there, do they have any meetings or anything that he could have been doing in the jail?
I mean, I attend church every Wednesday.
But you go to church?
Yes.
Okay, all right. Anything else that you want me to consider, Mr. Stoll?
No, sir.
All right, Ms. Robinson?
Your Honor, it appears that this defendant has drug charges in Missouri going back to 2009. It appears he's had a pretty consistent drug problem, at least based on his police history since then. As I've said before, the guidelines on this were 0 to 17. People offered a cap at midpoint. Your Honor sentenced him to 6 months, which is less than you could have. In addition, the people dismissed as part of this a felony firearm with a pneumatic gun, so he could have been facing much more time with that charge on there. So based on that and the defendant's history, the people would argue that he got a pretty good deal here and that no additional benefit is necessary. Of course, as this court is aware, it is entirely at the court's discretion, and I have nothing further to offer the court in making that decision. Thank you.
All right. Well, the court's going to deny the motion for reduction of sentence. We got 20 days left. I hope that you do well once you get out. As the prosecutor indicated, you know, they felt your sentence should have been 9 months. I took 90 days off of it at that time. Yeah, I don't see anything exceptional here why we're making additional reductions. So court is going to deny your request for a reduction in jail sentence. Hope you do really well on probation. It sounds like your mind's in the right place. Sounds like you're gonna be all right.
Thank you, sir.
The one guy had 18 days to go. This guy had 20 days to go. Like, why waste the court's time on this? You only have a couple weeks. Just to finish it out. Right. My goodness. Oh, Spider-Man, that is so sweet. Thank you so much for reminding people. I love you.
And then in the courtroom is Mr. Alec Bergen, 404607338. This is a return on 1077 evaluation, and after the court does that, we're going to ask the court to accept a plea.
Have the parties had a chance to review the evaluation?
Yes.
Does either party take exception to the court adopting the opinion that Mr. Bergen is able to proceed?
No.
I am going to make that finding then. As such, the case may proceed.
And Your Honor, in this matter, we are asking the court to accept a plea of guilty to both a criminal trespass and malicious mischief. And this is a request to enter into a deferred sentence. I did go over the plea paperwork with Mr. Bergen, went over the rights at arraignment, went over the went over the rights that he is giving up by pleading guilty, went over any immigration consequences that he may face as a result of being convicted of this charge, went over the conditions that he would have to abide by if the court were to grant the deferred sentence, or also discussed with him the possibility that the court could not grant the deferred sentence and just sentence him on this case. And I believe he's making no involuntary intelligent decision to plead guilty at this time, so we are asking the court to accept the plea.
And it was Eva Baker, right?
So is a doctor? Yes, I believe so.
So Mr. Bergen, I have a document here entitled Statement of Defendant on Plea of Guilty. Towards the bottom of it, on the line that says defendant's signature, it's blank. Have you not signed this document yet, just because you have no way to sign it?
I believe that's correct.
If you had had a way to sign it, would you have signed it?
I'm still a little like, I don't know, it's one of those things where like, I haven't really had much time to think about it. I think I'm good to sign it, but I guess I'm having a little bit of concern right now.
Want to talk to Mr. Ignati for a little bit?
Is that
Yeah,
acceptable?
we'll go back into a break room and talk again.
Okay, sorry.
You're fine. You're gonna just click join when you see it. And he should be coming back in a moment. You're gonna need to, yep, there you go. And I believe I answered all of his questions, and we are asking the court to proceed with the plea.
Next, Bergen, are you ready to move forward now? Did you have all your questions answered?
I believe so, yes, thank you.
Okay, if you had had a way to sign this document, would you have signed it?
Yes,
SCORE will give you a chance to sign it after this hearing. Do you promise to sign it at that time?
I do promise to sign the document.
When you reviewed this form with Mr. Ignati, did he read it to you? Did you read it by yourself, or did you read it together?
Together,
And was he able to answer any questions that you had?
yes.
As I review this form with you, please stop me at any time if you'd like to ask him another question.
Okay,
Is your true and correct name Alec J. Bergen?
that's correct.
And you're 30 years old and have completed more than the 12th grade?
That's correct.
You're pleading guilty to 2 crimes today: criminal trespass in the 1st degree and malicious mischief in the 3rd degree. Do you understand the elements of those crimes? In other words, what the city would have to prove if you were to take this case to trial?
I don't necessarily know the elements of the case.
It's what we went over earlier, but if I can go over it again, it's elements are like what the facts of the case are that make the crime.
Like time, place, and was intent important?
So on the criminal trespass, it's entering or remaining unlawfully in a property.
Okay,
The malicious mischief is causing physical damage to the maliciously or intentionally causing physical damage to the property of another.
that's why with the intent, I don't like with the mental health aspect of it, I'm not sure if that's, I guess, you know, I do want to get out of here, and risking another month in here is a little too much. Let's just keep going.
The fact that you want to get out is not, I can't accept a plea based on that.
Oh, I mean, it's fine. I'll plead guilty to it. I don't believe I was intentional, but I think I will plead guilty to this.
I can meet with him, Your Honor.
You want to discuss an Alfred plea?
I can. All right, so I'm gonna send you another invitation, Mr. Bergen. I think we're ready. And we are just asking to proceed as is, Your Honor. I did go over all the different options with Mr. Bergen. And it sounds like this is what he would like to do. So we are asking the court to accept the plea as is.
Okay, so I'll pick up where I left off. Do you understand the elements of these crimes? In other words, what the city would have to prove if you were to take this case to trial?
I do.
By entering into this plea, you're giving up a number of very important constitutional rights. Among these are the right to a speedy and public trial, to remain silent during that trial, or to choose to testify, to see, hear, and question witnesses who would testify against you, to have witnesses testify on your behalf at no expense to you, to the presumption of innocence unless and until a jury were to find you guilty, and to appeal a finding of guilt. Do you understand you're giving up all those rights?
I do understand.
Both of these charges, criminal trespass in the 1st degree and malicious mischief in the 3rd degree, are gross misdemeanors punishable by up to 364 days in jail and a $5,000 fine. Is that your understanding?
$5,000 fine each, correct?
Correct.
Okay,
Do you understand that?
I do.
And I know your attorney and the city attorney have an agreed recommendation for a deferred sentence, but the court does not have to follow that and can sentence you anywhere up to the maximum, including running them consecutive to each other for almost 2 years in custody. Is that your understanding?
Yes.
Do you understand in the event you're not a citizen, a guilty finding on either of these charges may be grounds for deportation, denial of naturalization, or exclusion from the United States?
I do understand this.
Did anyone make any promises to you to get you to enter into these pleas?
There were no promises made, no.
Did anyone make any threats to get you to enter into the plea?
No threats were made.
Are you doing this of your own free will?
I am doing this on my own free will.
In paragraph 11, there's a statement that reads, on November 17th, 2024 in SeaTac, Washington, at the SeaTac Airport, Port of Seattle, I knowingly entered and remained in the airport without lawful authority to be there. And on the same date and place, I maliciously damaged another's property without permission to do so. I know your attorney wrote that statement, but do you adopt it as your own statement?
I will adopt that statement as my own.
Is it a true statement?
It is a true statement.
As to the crime of criminal trespass in the first degree, how do you plead?
I plead guilty.
As to the crime of malicious mischief in the third degree, how do you plead?
I plead guilty.
I will accept the pleas. I do believe they're knowingly, voluntarily, intelligently made, and there's a factual basis to support them. Ms. Chinweller, anything to add to the sentencing recommendation?
An agreed recommendation for 24-month deferred sentence, including mental health evaluation and treatment and restitution reserved.
Mr. Arnott?
Your Honor, this is an agreed recommendation. Mr. Bergen does have, it sounds like he's made some connections there at the jail and has housing set up for the next 6 months. The city made an offer that I don't think I'm going to violate the plea. They made an offer that was didn't involve any kind of probation with the court or besides law-abiding behavior. And Mr. Bergen was hoping to get his life on track and do certain things to get the benefit of a deferred sentence, and that included getting the mental health evaluation and complying with it, which he believes that he could benefit from. And so he is hoping that the court would give him a deferred sentence. And I did go over the Community Resource Center with him as well as a resource to get access to the mental health evaluation. But it sounds like he is engaged with a program right now that's helping him kind of get connected to these services.
Next, Bergen, is there anything you'd like to say?
I do not believe so. I guess I would like to emphasize that looking forward, and I'm very eager to get my life together. I'm going to be working with LEAD and telecare, telehealth for the next 6 months in housing, and then hopefully a transitional housing be housed after that.
Wonderful. I'm so glad that you were able to take advantage of resources while you're at SCORE. I am going to follow the agreed recommendation. I do think it's appropriate. I'm going to defer sentence for 24 months on both counts. Do you receive government benefits?
I do. Just cash benefits that are food benefits.
Sentence will be deferred for a period of 24 months on both counts. I'm further finding that that you're indigent by virtue of the fact to receive government benefits. I'm not imposing any fines, fees, costs, or assessments other than restitution, which I'll leave open for 180 days. So if the city receives information, they can request a hearing at that time. For the next 24 months, you need to abide by the following conditions. Attend any future court appearances, have no new criminal law violations, have no contact with SeaTac International Airport or the rental car facility except for valid travel purposes. So unless you have a ticket to fly somewhere or rental car contract, you cannot be there. Update your address with the court and DOL immediately if there are any changes. And do you know where you'll be living?
So Stephanie said that by the end of today, she'll have an address for me.
Okay, so when you know that, please call the court and update it.
Call the court, okay.
Within 60 days, obtain a mental health evaluation, and within 90 days, begin any recommended treatment and file proof of all of that with the court.
Okay, great.
All right, thank you very much. I wish you well. I hope that that the housing and treatment, turn things around for you.
Thank you. I appreciate your sentiments.
Okay, you can let the guard know you're done. Thank you.
All right, thank you.
This one's fun.
Good morning.
Morning.
This is Miss Taylor Ann Schlewitz, is that right?
Yeah.
5A0121156. Here for Arraignment. Is Taylor Ann Schlewitz your true and correct name?
Yes.
Your date of birth is December 24th, 1991.
Yes, sir.
Earlier, I went over your right to arraignment with you. Any questions about your rights I wasn't able to answer?
No, sir.
All right, I've gone over the charge, the maximum penalty, and the mandatory minimum penalty. We'd acknowledge the complaint, wait for a reading, and ask you to plead not guilty.
Plea of not guilty will enter. Probable cause was previously found on February 6th. What is the city's recommendation regarding?
Based on defendant's more than 5-year prior history, including 2 active warrants out of Linwood Municipal Court, city believes the defense a high risk of failures to appear, is requesting bail in the amount of 500 cash or bond and standard conditions, including no contact with the airport.
Any objection to those conditions?
Your Honor, I know Ms. Schlutz has indicated she's aware that she has to take care of some other matters. She's hoping the court releases her on this case. It is a good address. She does have the ability to show up for court and abide by the other conditions, and she's would screen for the public defender. Release.
Ms. Chenwiller, what is, other than the active warrants out of Linwood, what warrant activity does Ms. Schwartz have?
I do have, and I had notes from the 2 previous dates where the defendant refused that there was also a warrant out of Bellingham Municipal Court.
Yeah, I see that. I can scroll through your warrants now that it finally loaded. In 2024 alone, it 8 warrants in Linwood, 8 warrants last year alone. I am going to maintain bail in the amount of $500. Do you believe you'll be posting that amount?
I'm not sure. I was just hoping to see with my first court date if you guys could release me. I don't know why it said I refused court 2 days ago. They didn't even ask me to attend. They slipped me a piece of paper saying that I refused, but that wasn't even the case. Had I had the option to go 2 days ago, I would have been there. So this just keeps getting dragged on and prolonged anyway. That's not how I even like handling things. Like, if you guys could release me and so I can get these warrants taken care of. Bellingham and Linwood, I don't think is even gonna do anything to me or for me if I stay here just to try and clear that up. I just can't see, I just don't see any point in doing anything other than trying to release me today.
Well, I tend to disagree with you, given that, as I said, you have 8 warrants last year. You have 8 times when you didn't come to court, which says to me, you're not likely to come back to court.
For CTAC, ma'am?
Nope, for a number of different courts. So I do think posting bond is appropriate in this case. I believe you're a flight risk.
That's not possible for me. I can't do that. So how long am I gonna be here for?
We can set this over till later this week
What would be the point of that?
to resolve your case, one way or the other.
Why can't we resolve it today?
Ms. Reinati, she does have a right to plead guilty at arraignment.
I agree. I mean, I can.
What?
I guess I agree. I just, right now, I think we proceeded with the arraignment, so I don't know if that's the same situation, but I can talk to her about entering a plea today if that's truly what she wants to do.
If I plead guilty today, can I get
Hold
released?
on, don't say anything, because I don't know that that's what the city is recommending either, so. I can go into a breakout room with, I think, if you could send me an email, Ms. Chenwaller. Ms. Stewart, I'm gonna send you a request to go into a breakout room. You could use the mouse to click join. We are ready to proceed. I did speak with Ms. Stewart about her right to plead guilty, and it sounds like she does want to plead guilty at this time. So I filled out the plea paperwork, went over the rights that she is giving up by pleading guilty, went over the entire document with her. I believe answered all her questions about pleading guilty, and I have gone over any immigration consequences. So we are asking the court to accept this plea at this time.
Ms. Schlewitz, can you please unmute?
Yeah.
So I have a document here entitled Statement of Defendant on Plea of Guilty. Towards the bottom of it, on the line that says defendant's signature, it's blank. Have you not signed it yet just because you have no way to sign it?
Yes.
If you had had a way to sign it, would you have signed it?
Yes.
SCORE will give you a chance to sign it after this hearing. Do you promise to sign it at that time?
Yes.
When you reviewed this form with your attorney, did he read it to you? Did you read it by yourself, or did you read it together?
Both.
Was he able to answer any questions that you had?
Yep.
As I review this form with you, please stop me at any time if you'd like to ask him another question.
Okay.
Is your true and correct name Taylor Ann Schlewitz?
Yes.
And you're 33 years old?
Yep.
What is the last level of education you completed?
GED.
Do the parties have any objection to me adding that?
Oh, yeah, no objection.
You're pleading guilty to the crime of criminal trespass in the first degree. Do you understand the elements of that crime? In other words, what the city would have to prove if you were to take this case to trial?
I believe I do, yes.
By entering into this plea, you're giving up a number of very important constitutional rights. Among these are the right to a speedy and public trial, to remain silent during that trial, or to choose to testify, to see, hear, and question witnesses who would testify against you, to have witnesses testify on your behalf at no expense to you, to the presumption of innocence unless and until a jury were to find you guilty, and to appeal a finding of guilt. You understand you're giving up all those rights.
Yes,
The crime of criminal trespass in the first degree is a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine. Is that your understanding?
yes,
I know your attorney and the city attorney have an agreed recommendation, but the court does not have to follow that and can sentence you anywhere up to the maximum. Is that your understanding?
yes,
Do you understand in the event you're not a citizen, a guilty finding on this charge may be grounds for deportation, denial of naturalization, or exclusion from the United States?
yes,
Did anyone make any promises to you to get you to enter into this plea?
no,
Did anyone make any threats to get you to enter into this plea?
no,
Are you doing this of your own free will?
yes,
In paragraph 11, there's a statement that reads, on February 5th, 2024 in SeaTac, Washington, at the SeaTac Airport, Port of Seattle, I knowingly entered and remained in the airport without lawful authority to be there. I know your attorney wrote that statement, but do you adopt it as your own statement?
yes,
Is it a true statement?
yes,
As to the crime of criminal trespass in the first degree, how do you plead?
guilty,
I will accept the plea. I do believe it's knowingly, voluntarily, intelligently made, and there's a factual basis to support it. Ms. Chenweller, anything to add to the sentencing recommendation?
It is an agreed recommendation subject to Blazina inquiry. Defendant has 6 days credit for time served, asking for conditions including no contact with the airport and clear the 2 Linwood Municipal Court and 1 Bellingham Municipal Court warrants by March 10th.
thank you.
Carnati?
And, this is an agreed recommendation. Ms. Stewart does plan on taking care of her warrants. She does receive food stamps and, was on SSI, but that sounds like she's still working to try and get on SSI. Is not currently working. So she is hoping the court reduces whatever financial obligations are, and follow the recommendation.
Ms. Schlein, is there anything you'd like to say?
No. Yes, review.
I am going to follow the agreed recommendations. So some as follows. 364 days in jail with 358 suspended with 6 days credit for time served. $5,000 fine, all 5,000 suspended as I'm making the finding that you're indigent. I'm not imposing any fines, fees, costs, or assessments, and there's nothing mandatory for this charge. Jail time will be concurrent with any other holds, and the court is taking 24 months of jurisdiction. For the next 24 months, you need to abide by the following conditions. Attend any future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes. And the address we have on files on Stone Avenue North, is that still a good mailing address?
Yeah,
And have no contact with SeaTac International Airport or the rental car facility except for valid travel purposes. So unless you have a ticket to fly somewhere, you cannot be there.
okay,
And by March 10th, so 30 days, you have to clear the warrant, 2 warrants out of Linwood and 1 out of Bellingham.
okay,
I put on here also the dates of our next 2 community court resource centers. It sounds, looking at your history, it seems like you're located more north of here. But if SeaTac is convenient for you, you're more than welcome to use the resource center. We have all kinds of different things. We can help you get back on SSI, state insurance, housing, jobs, anything that you'd be looking for. The next one is Wednesday morning at 8:30. It runs all morning, and then the one after that is Wednesday, February 19th in the afternoon. And if you miss both of those and are still interested, feel free to call the court, and we'd be happy to let you know in the next one.
okay,
And I am appointing Mr. Arnotti's firm to represent you.
Okay.
Okay, all right. Thank you. I wish you
Okay.
well.
That was awesome, as usual. And you guys made it amazing. Jeez, Ava, you're getting kind of chunky. I can hear you breathing. Oh my God. That's so cute. You guys are so cute. Hi, baby. Oh, my precious angel. Yeah. There's a lot of songs from that era that if you listen to the words, they are absolutely stocking songs. And I'm all here for it. Cause, I mean, that's my kind of love. Whoa. I guess I gotta go. Thank you all for coming out tonight. I love you so much. And I can't tell you how much I appreciate every one of you. Be safe, be well, sleep sweet, and much love.